Assalamu alaikum and good afternoon, everyone. As you're all aware, my name is Syed Imran Waheed, and I am the Executive Vice President and Head of Construction Management Division at NESPARC. On behalf of NESPARC and NESPARC Trainings, I welcome you all for this webinar on the topic of international international arbitration. Before extending invitation for this course, I think we had decided that we will extend the invitation to participants outside NESPARC as well to ensure maximum participation from others also. And I believe that we have among us people from clients and other consultancy firms also. As I see most of the colleagues in NESPARC, they are related with construction management, and they are dealing with disputes, construction disputes on a daily basis. And I'm sure this webinar, the information shared in this webinar will definitely help them, will provide them useful information on the subject. We have three distinguished guest speakers today who are going to share information with us on the topic. I'll briefly introduce you to the guest speakers. Our first guest speaker will be Mr. Nasir Khan. Mr. Nasir Khan, he is the Director and Head of Dispute Resolution at Curie and Brown, UK. He is a recipient of Member of the Order of British Empire. He is a qualified engineer and commercially and legally trained to provide commercial procurement and legal support on domestic and international projects. His area of expertise is dispute avoidance and management, arbitration, mediation, and so on related to arbitration. Our next speaker, guest will be Barrister Mian Sheraz Javaid. He is a founding partner of MK Consultants UK. He is basically a civil engineer with Masters in Construction Law and Dispute Resolution from King's College London. He has been working as a construction lawyer for the last 15 years. And his practice area focuses on construction contract drafting and dispute avoidance and alternate dispute resolution. Our third guest today will be, she's not with us right now and she will join later on at about 2:30. And she is Margherita Blandini. She is the Head of Education and Project Management at Chartered Institute of Arbitrators. And she has an experience of over 15 years in legal education sector. All these three guests will share with us information on the topic of international arbitration and an upcoming course that is to be arranged by Chartered Institute of Arbitrators Pakistan branch in Lahore on 28th August for people interested to participate in the course in Pakistan. So they will provide you all this information during the next an hour or so. Now I will request Mr. Nasir Khan to carry on from here. Mr. Nasir Khan.
Thank you, Imran. Assalamu alaikum, everyone. It's an honor and privilege, again, as always, to come and speak in front of you all. It's a great opportunity to discuss. International arbitration it could be perceived as a complex subject, but as we know, construction is a complex subject. Construction projects are becoming more complex and are being implemented on a much larger scale. We face many issues in every aspect of business operations. However, it's down to us, the practitioners, to be resilient, be able to identify, evaluate, and mitigate these issues. To talk about arbitration or international arbitration, we have to set the scene and develop the context of why do we need to understand arbitration? Why do we need to understand dispute resolution? What is happening? I mean, you're all very familiar with what COVID-19 has brought to us. It has brought to us unprecedented challenges. It has had a global impact in ways we could not have foreseen. And our sector, the construction sector, is no exception, whether it's infrastructure, building, housing, port, marine, railway, utilities, energy, whatever it is. Public and private sectors have the responsibility to work collaboratively to ensure that we emerge, from these issues collaboratively with capability and capacity required to support the economic rebuilding of our jurisdiction. So in your case, it's Pakistan. Now, COVID-19 is not the only pandemic that our industry faces. Our sector is marred with costly delays, cost overruns, disputes, risk, liabilities. There is an increasing need to have a clear strategy on how to draft, manage, and negotiate construction projects in a way that it protects the intended goals and objectives. What I'm planning to do in the next 10 minutes or so is to give you a bit of an overview of global dispute resolution and how it compares with dispute resolution in Pakistan. Over the last 4 months, with support of NESPAC, especially Imran, thank you very much again, we have been compiling a dispute report on construction industry in Pakistan to try and ascertain what happens. And I'm going to show you some of those results today to ascertain why disputes are happening, how we resolve them, and what arbitration plays an important role in all of that. So I will just continue. So these are the contents. I've kind of given you an overview. Thank you, Imran, for giving a great introduction. So I work for Curie & Brown, which is a global consultancy across the globe, a lot of operations in China, Middle East, UK, Americas. And it's basically every aspect of the construction asset management that we get involved in. So I'm going to just focus through some of the sectors that the business works in, and I've personally worked in most of these sectors as well. So I head up the contract solutions team, which works across Europe and a lot in the Middle East as well. And we provide expert support in arbitrations. And also, some of you may be familiar in the UK adjudications, which is a statutory. So global disputes, something I really want to talk to you guys about is how global disputes actually work in this scenario. In terms of global dispute resolution, we need to think about how projects are being delivered. The research provides us with information that 80% of large infrastructure projects globally experience cost or program overruns, which result in disputes. Now, disputes, as we all know, is a misunderstanding when two parties do not agree with what they are planning to deliver. The average value of contract disputes and length of resolution in the construction engineering sector can vary between 15 months and 5 years. And I will show you some of these results in a second. Large infrastructure projects, it is perceived that 98% of them will suffer cost overruns. Now that is a massive, massive burden on anybody delivering those projects, because at a point when engineering is all about delivering it with efficiency and optimization of cost. So I'll talk to you about a little bit about the construction dispute survey we did. We can all come in and talk about and say, oh, you need to learn about arbitration, you need to learn about dispute resolution. But first we need to understand why do we need to do that? And that was the main purpose of Pakistan Construction Dispute Report, to actually identify the root causes, how we can actually implement appropriate strategies, which will equip everybody at NESPAC to be able to deliver your project successfully. Now, major causes of global disputes. This is a global scenario. If a contract is not written appropriately, it will be poorly drafted, incomplete, and the claims that will be submitted will be unsubstantiated, because the principle and quantum are two separate issues when a claim is raised by either party. Extension of time is a big issue. And then the other aspect that is found globally is people not understanding their contractual obligations, not having the appropriate contractual training, or not understanding how the provisions in the contracts operate. The global average value of disputes in 2019 was 30.7 million US dollars. That is quite high in comparison to what it was in 2018, which just goes on to show that the trajectory is going up, not down. Now, I want you guys to think about how it correlates with dispute resolution in Pakistan. The biggest issue in Pakistan that we have found from various jurisdictions, and I will show you some of these, is payment delay. People are not being paid on time. It could be from the government sector, it could be from the private sector, but that is the biggest cause of a dispute. Now, why we did this research was to try and understand, in the same way as a research was done in the UK about 27 years ago, Sir Michael Latham, constructing the team, some of you may be aware of it, was all about trying to find why there are so many disputes occurring in the construction industry. And they also found the same result. It was payment. Cash is the lifeline and blood of the construction industry. And if payments are not made on time, we will have disputes. Now, how to resolve these disputes? When you are not being paid, do you go to court and litigate? How long will that take when a country like Pakistan has 2 million cases pending in the commercial and civil courts? You will be looking at another couple of years before your payment case will be heard. It's just not appropriate. It's just not practical. So in the UK, a statute was designed called the Construction Act, through which if you have payment disputes, you can take the matter to adjudication, which is private dispute resolution. Now in Pakistan, we don't have adjudication, but we have the next best thing at the moment, and I will show you the data, which is arbitration. Because if you have issues and disputes, you're taking the other party to arbitration. So your case is heard in a bit more urgency, well, dependent on the arbitration scenario and how you are actually delivering it. Behavior and competency, again, it goes back to the same issue, that people not understanding their obligation, the master and servant proposition in the construction industry, clients not behaving appropriately, contractors not behaving appropriately, and extension of time. What is the root cause of that extension? Who was the cause of that delay? Was it an incomplete or late design? Was it materials not turning up on site on time? Was it, subcontractor or supplier issue, workmanship error? It could be many reasons that could infiltrate extension of time, making it one of the biggest reasons. But the key provision that comes in is all of these can be resolved through dispute resolution. In terms of how globally disputes are resolved, I just want to quickly go through this because I want to finish my work in the next 5 minutes. Is party-to-party negotiation is the #1 ranked. What happens when we have a problem with somebody? We discuss it, We negotiate it, we try and find a solution. We try and find a mutual ground, win-win situation, or some may call it lose-lose situation, depending on which side of the spectrum you are. Mediation is becoming quite prevalent in the global industry, not as much in Pakistan at the moment, especially in construction disputes, although there is quite high number of mediations happening in family courts in Pakistan. Arbitration, number 3, that's global. I'll just give a quick matter in the UK. In the UK, the number 1 dispute resolution method is adjudication, which is something that doesn't happen in Pakistan. Although, if you are operating the FIDIC contracts, you will have adjudicators under the contracts. And that's how some of those matters should be resolved via the dispute adjudication boards. So we need to see a high number of that. In Pakistan, as you can see here, the adjudication matter on FIDIC, only 1% of disputes that we surveyed were resolved through that. Of course, negotiation with the other party, it kind of comes in our nature, culture, faith, as following our Sharia and Islamic tradition. We like to negotiate with the other party rather than go full on bang, see you in court. That doesn't happen as much in the construction industry. Litigation is only in 6% as the last resort, because we all know litigation takes a lot longer than arbitration, conciliation, or any other method. I was really surprised to see mediation at 9% as well, which was really, really good. But then the key aspect is arbitration and adjudication are quite prevalent, and we need to see how they operate. So we asked, I'm going to just rush through that, is what are the dispute mitigation methods in Pakistan? It's quite variant. Relationship management, risk management, all of these are happening. So as I mentioned, arbitration, 25%. Sorry if my slide did not move at that time. Is my screen still shared?
Yep. Yes, sir.
Good.
Sure.
Thank you. Thank you. So global dispute mitigation methods, again, owner's willingness to compromise, contractor transparency of cost data. I've just mentioned to you in Pakistan, we are looking at risk management and relationship management, and dispute avoidance boards are also forming up now, which is again, a key requirement under the World Bank and the FIDIC contracts. Some other quick findings. These are the different type of people that we engaged with. Majority of them were clients, but there was a good number of consultants on both spectrum, consultants like yourself and also law firms as well, some contractors. We tried to look at different provinces. For some reason, we had a lot of results from Khyber Pakhtunkhwa, which was great. Average disputes per project. Now this is very interesting because this is what I want to show you all is there was only 3% projects reported with no disputes. I mean, you're all practitioners. You can also tell about your projects, what you think. Do you resonate with this? 65% having 1 to 5 disputes. How are we going to resolve these disputes? What are the dispute resolution methods we have? Do we have ADR awareness in our industry? Okay, I don't know what maybe is, but some people responded to maybe. Is there success in ADR? 49%, 37% with a maybe. So enforcement, and then Mian Sheraz will talk a little bit about Pakistan's arbitration law. And is the legal system supportive of ADR? I could not have seen any better split. It's almost 1/3 for each option. Yes, no, maybe. So growth of ADR, of course, there is a humongous growth of ADR in Pakistan. There is a lot happening. There is a lot of specialist courts being formed. Commercial courts have also been formed in Punjab. So as I mentioned, global dispute resolution. And if we look at Pakistan, we need to think about payment delays, behavior incompetency of people. So delivering your projects, you need to keep an eye on these issues because these are the biggest causes of your disputes, and how you can resolve them are these 3 key methods. And so again, what's next for Pakistan? This is where I think you're all familiar that we've been working, and Imran has been an integral part of that, forming Chartered Institute of Arbitrators Pakistan branch, which is again to introduce and implement alternative dispute resolution methods in Pakistan, not just in the construction industry, but varying industry. Of course, there's a bias because of our construction background that we focus on construction quite a lot. But this is where I will leave you to then be spoken about these with Mia Sheraz, so he can actually talk to you about what needs to be done and delivered in terms of international arbitration and international arbitration in Pakistan. Please do ask questions in the chat box later on, and I'll stay. And if possible, we will answer your questions later on as well. And I'll share the slides with you as well later on. Mia Sheraz, over to you.
Yes, thank you, Nasir and Imran. Assalamu alaikum to my fellow members of my engineering fraternity. So as Nasir has given the startup about the disputes in the construction industry, construction being the biggest contributor of the global economy, and it plays the vital role in the national development. Almost between 15 to 20% of Pakistan's national economy is of the GDP is supported by construction. So we are talking about billions of rupees turnover, and these development projects, these are very crucial to be developed, to be completed on time, which is our aspiration. We want these construction projects to be completed well on time. In my humble opinion, the key to have projects developed right on time is the professional training. We need to know what are the rights and the obligation as described in the contracts. But right now we are here to talk about once the dispute has arisen, it has been crystallized. So what are the ways, especially with regard to the international arbitration, and how we do that? I work as a partner with MK Consultants. It's an LLP. We are also trying to put our foot in Pakistan. We do pre-contract, post-contract dispute resolution. Being a barrister and with the engineering background, I deal in all aspects of construction contracts, and we do also deal in training and a bit about our experience. So these construction disputes, we need to understand why do we call them the international arbitration. Arbitration is a process, and when it involves companies from multiple jurisdictions, then it automatically becomes international arbitration. We all understand disputes bear heavy on both sides. It's not just the visible expenses. Like there are a number of things. Visible expenses mean the attorneys, expert witnesses, the process, the time. But there are also the less visible costs, which involve resources, the intangible costs, reputation damage, and then the relationship damage, and the number of other things. We have to put in all our efforts to avoid the dispute. But once a dispute has been crystallized, a dispute has been we have been hit by a dispute, then we need to see what are the dispute resolution methods, how we can deal with them. So this picture is very self-explanatory. Litigation is the pit hole. If you are going to try to resolve a dispute through litigation, that is like as Nasir expressed, a couple of years might not bring you even the startup of the case. Especially in Pakistan, we have got around 2 million pending cases before the legislature. So there are a number of options. Rent a judge. This might sound funny, but arbitrators are considered to be to belong to this rent a judge option, where you actually and this is one of the most popular ways when in the arbitration industry. Dispute boards, partnering, mediation, conciliation, negotiation, all these things, these are the methods which are invoked between party to the party. So the hostility is less, because once the parties can negotiate things between themselves, they have the liberty, they have certain advantages over it, the costs are less. But once the things go out of your hands from the two parties when you refer the matter to a third party, a judge or maybe an arbitrator. So the degree of hostility is increased, and so the cost is. As you can see in this slide, litigation is the most costly thing, then arbitration, then the boards, and then we come on to mediation, conciliation, negotiation. Um, so it is always recommended to have the dispute settled among the parties at the initial stages. So let's come on to the arbitration. So arbitration is a process in which a dispute is submitted to an impartial arbitrator, an outsider who makes a decision which is usually binding on the parties. This arbitration thing, it gets started with the arbitration clause, which is mandatory to be present in the contract. In jurisdictions like England, where we have mandatory arbitration or adjudication, unlike in Pakistan, we don't have anything prescribed by the law. So this agreement is the contract between the two parties that is the foundation to refer the matter to an arbitrator. If we don't have the arbitration clause in the contract, the matter will be sent to the courts, and we don't want that. So in terms of international arbitration, it is a technique for finding a solution to conflicts outside the court. The best thing about arbitration or international arbitration is the parties have the liberty to appoint qualified arbitrators. I've used the word appoint because the appointment of the arbitrator is done in consultation with both the parties. So there is a mechanism where you refer the matter to a third. Normally, if it is an institutional arbitration, so the institute gives you or provides you multiple CVs of those professionally qualified people belonging to your specific issue, and the parties can then either choose one arbitrator, or if they are unable to choose one arbitrator from the three CVs, so both the parties can choose one arbitrator each, and then the two arbitrators can then engage an umpire for the decision of the matter. So this arbitration or international arbitration, it is a private dispute resolution rather than public dispute resolution. So in courts, we all know it's an open court. Everybody, and anyone can come to court and hear the proceedings of the court. Anyone can apply and get the documents of the court proceedings, which is not the case in the arbitration. Arbitration is totally confidential, and the arbitrator is also bound to confidentiality. And it is this arbitration, especially the international arbitration, is the designated default dispute resolution in disputes between governments and companies. We have been hearing about a number of cases. The most prominent one was the Rithodic one, where we were hit by a $6 billion award by an international arbitrator. And even in certain cases, if you don't have the arbitration clause, but the contracting party, one of the party belongs to another country. So we have got bilateral investment treaties and different other umbrella agreements signed between the two countries that actually empowers the private party to bring an international arbitration proceeding against the governments, which has been happening quite frequently in Pakistan. So what happens in international arbitration is you refer the matter to an arbitrator, and then the arbitrator issues an award. And the beauty of the international arbitration is you can get the enforcement of that award from any of the 156 signatory countries of the New York Convention. So Pakistan is also a signatory to the New York Convention. So if an arbitrator issues an award against Pakistan, government of Pakistan, or a private company in Pakistan, that award can be enforced in any of the 156 countries, like in Copper Tatian, the Rithodic case, the party who got the award wanted to sell the Rose Wallet Hotel owned by the PIA or the government of Pakistan in New York in lieu of the other charges. So it is not about like for the national courts in international arbitration, if one party is from Pakistan and the party is from the other country, so the Pakistani company or the Pakistani government will by default have the edge of their home ground or their home courts which might not be appropriate or which might not considered to be neutral for the non-Pakistani party. So these are the elements which actually supports or provides a mechanism or how to take on the international arbitration. So why choose international arbitration? As Nasir said, and which is a fact, there are too many pending cases in the courts of certain countries, not just about Pakistan, that the only Pakistan has got so much of cases. If you talk about the regional areas like India, Bangladesh, Sri Lanka, and some other countries, some Western countries as well. So they are too burdened with the courts, with the cases. There are certain advantages, there are certain disadvantages. I will have a word on what are the advantages of this and what are the disadvantages. But um, uh, we can get quick results through arbitration. And in certain cases, it costs less to the parties as compared to traditional court procedures, where cases can last for years. If possible, we can try to use a fast track procedure. One arbitration hearing usually takes place in a private room and can complete confidentiality. It's very beneficial, especially for businesses involved in a conflict, because it'll help them to retain their reputation among their clients. So that is why most of the construction contracts that invokes this. So what are the advantages of arbitration? Uh, it can be quicker and cheaper than litigation, but for small sized claims, because as the claim gets complex, the process gets lengthy in arbitration. The procedure is flexible, and then you have the choice of appointing the arbitrators, which is one of the best advantages. Like the judges, they might not be trained in construction terminologies or in energy terminologies or some other things. Um, so the best thing is the arbitrator is a qualified person. Uh, and I believe, especially in construction contracts, in infrastructure construction contracts, the engineer is the engineers are the best arbitrators. Although predominantly lawyers are considered to be arbitrators, but this is the domain specifically for the engineers who needs to be trained as arbitrators, because they understand how projects are developed. They know the ground realities. The only thing they have to pick and adopt is to get certain training about these legal issues. Uh, so in most countries, enforcing a award is usually more straightforward than enforcing court judgments. Like a court judgment from Pakistan might be difficult to be enforced within Pakistan as compared to a foreign arbitral award, because we have enacted certain legislations that allow speedy processes for the execution of those judgments. And then in international disputes, the international arbitration, it can prevent different countries the conflict of laws. So instead of the law of contract from one country and the interpretation of the contract from some other country, and multiple legal issues when we are hit with that. So reducing the possibility of forum shopping is considered to be the terminology, that instead of going on different multiple jurisdictions, we can go to international arbitration. The arbitration clause, if well drafted, can actually compose all these shopping or all these forum shoppings in one arbitrator. But besides that, there are certain disadvantages of arbitration as well. The Unlike judges, the arbitration fee must be paid by the parties. This can be expensive compared to conventional court fee in many jurisdictions. So we need to evaluate money versus time. If you can spend some good bucks and get the dispute settled in less time, it can be more beneficial than spending no money or less money in courts. But in certain jurisdictions like England, litigation is way too expensive because the losing party has to pay the costs of the winning party as well. The arbitration can sometimes become more time consuming if we are hit with complex issues. Unlike mediation, arbitration is an adversarial process, which means like an arbitrator will not use its own mind. It has to adjudicate on the documents provided to him only. In courts, they have the um, uh, non-adversarial process where they can investigate who is right and who is wrong. And then international arbitrate might be difficult for where multiple parties are involved. Then all the contracts with all these parties needs to be on a harmonious note, empowering one forum to arbitrate, which sometimes become really difficult in arbitration. So there are two type of arbitrations. One is ad hoc, and the other one is institutional arbitration. And then it all depends how you have drafted your arbitration agreement. Ad hoc is the one in which you have not nominated anybody. When at the time of dispute, you nominate somebody, and there are third party who can choose any of the rules, and then start adjudicating on the thing, versus the institutional arbitration. In like the institutional arbitration is an organized thing. There are certain institutes that provide that regulate the arbitrators, that provide arbitrators. They sometimes administer the arbitration process. They sometimes don't administer the arbitration process, but they provide you with the CVs of the arbitrator. And then so from institutional point of view, you get the rules. There are regional arbitration centers. There are global arbitration centers working in. So who runs the arbitrations? So like the Chartered Institute of Arbitrators, one of the regulators who train arbitrators. We have got around 16,000 members worldwide. Then the ICC, the International Chamber of Commerce, the London Court of International Arbitration, Singapore International Arbitration. We have got DIFC in Dubai. So there are a number of arbitrations. The CIArb Pakistan branch is going to be one of the arbitration centers, the first arbitration center for the Pakistani jurisdiction. So how do we commence this? Uh, Number one, we need to have the arbitration agreement. So if we have an arbitration agreement, the arbitration agreement will define whether we have a person by name mentioned as an arbitrator, or we have an institute or nominated body for the appointment of arbitrator. So once the dispute has been crystallized, we are unable to settle the dispute between the parties, then we serve a notice both to the other party as well as to the nominating body. So then the process begins. And then the nominated body and gives you the CVs of the arbitrators within a specific time, whatever the rules has been designed. So these are the four phases of the whole elements. We negotiate, we sign a contract. Phase one is very important because we need to draft the arbitration clause very carefully. And then when the dispute arises, usually we have multi-tier dispute resolution mechanisms. We do negotiations or mediation. If we fail this, we request for arbitration, arbitrator is appointed, the procedural issues, award is given, and then we look for the enforcement of that award. So the most important thing, drafting the agreement clause. This is the most important part, as I have said, because this is the first step in arbitration. Without arbitration, like in Pakistan Engineering Council have developed a dispute resolution committee, but people are reluctant to refer their matters to the PEC, because at the time of signing of contract, they have not agreed upon any arbitration clause, which is the best time to actually constitute an arbitration clause. Because when you are hit with the dispute, usually the parties, they don't cooperate with each other anymore. So it is important to carefully consider what is included in the arbitration agreement, because if something gets wrong in the arbitration clause, that can cost really big for the parties. And then there are certain elements which need to be considered. How do we create the arbitration clause? We mentioned number of arbitrators. We want one or three. If three, what will be the mechanism? What will be the seat of arbitration? Arbitration seat is very important, because if we are going to mention that the principal seat of arbitration will be Singapore, it will automatically mean that the laws of Singapore will govern the arbitration process. Or if we say that the arbitration seat will be London, so the laws of United Kingdom will govern the arbitration process. And then we can even mention the procedural rules. A number of things requires to be added, which language will be used, and how will we interpret the contract in case of a dispute. So all these things, they are very important in terms of drafting the So this is the sample arbitration clause which has been which is promoted by the ICC, International Court of Arbitration. There are a number of, you can find a number of sample arbitration clauses by different institutes. So in Pakistan, even like most of the cases in international arbitration, the FIDIC Red Book by default goes for the arbitration as a dispute resolution mechanism. And in FIDIC 4, the new FIDIC book, even the 99 version, they have multi-tier dispute resolution clauses. But the conclusion of a dispute can only be done not through the court but through the arbitration. And then, but in certain scenarios, as I have explained before, even if we don't have the FIDIC contract, but your contracting party is a foreign national, let's say that Pakistan was the first country in the world who entered into a bilateral investment treaty with Germany in 1962, I believe. So any German, if you are in a contract with the German party, and you don't have an arbitration clause in that agreement, but that bilateral investment treaty empowers the German party to actually come in and ask for the arbitration. Just like we have got CPAC contracts. So that CPAC contracts, we have the CPAC, we have got by default arbitration mechanism and procedure already written into it. And then we have got free trade agreements. So these are the umbrella things which are beyond the scope of the agreement, but those they provide by default all these mechanism how you can invoke arbitration. So and then the process, the mechanism of international arbitration is like the Convention for Enforcement. As I stated earlier, the New York Convention was signed in 1958. Then we had ICSID, the World Bank Convention, 1965. Then we have got UNCITRAL model rules. So we are signatory to New York Convention. We are signatory to ICSID, and then arbitration in Pakistan. We have got like this is something strange. We are still being governed by the Arbitration Act 1940 in Pakistan. It is a quite old one. We need to modernize the laws. Some new act drafts are pending before the legislators in 2015. But right now, the domestic arbitration is governed by 1940 Act, and then we have got two acts which were enacted in 2011 for the enforcement of the foreign arbitral awards. So if you have got a foreign arbitral award, then the process is different. It is a way speedy process than the process as compared to the local award. And so Pakistan frequently loses international arbitration. We lost $6 billion of arbitration in Ritodek because we lost the rental power cases with the government of Turkey, and the list goes on. We have got a long list of things happening against Pakistan. And why Pakistan loses international arbitration? It is because the inability to evolve a uniform law for understanding of contracts and the choice of arbitral frameworks. So at the time, we don't involve the right professionals at that time. We don't know what are the, like, we need to create a pool of experts who can take on this. And I personally believe these pool of experts should come from the engineering fraternity. There is a lot of room available in that. The importance of international arbitration, the engineering fraternity needs to come on board, which is why we are launching international arbitration course in Pakistan, which will be introduced by the Chartered Institute of Arbitrators. I would request Ms. Margherita, who is here with us from the Chartered Institute headquarters, to give us a brief of how these trainings happen and what are the benefits of these trainings and how we can become members of the Chartered Institute. Thank you. And I'm available even locally if somebody wants to contact me on email, question and answers after this session. I'm available. I'm available through Mr. Imran Waheed as well. Thank you, Imran.
Thank you very much, everyone, and good afternoon. It is a privilege to be here with you all on behalf of the Chartered Institute of Arbitrators, and thank you, Mian, for the very kind words of introduction. As after your very comprehensive presentation, I can just add that the Chartered Institute of Arbitrators, it is extremely glad that CIArb Pakistan branch is launching its first Introduction to International Arbitration course on the 28th of August in Lahore. And we are very keen to work with the branch to, first of all, raise that awareness of alternative dispute resolution methods in Pakistan, and also develop that pool of expertise that Mian was referring to, together. So what I will briefly present on today is how the Chartered Institute of Arbitrators training globally works. So what it is known as the Golden Thread, which is our global training framework. All the courses that the Chartered Institute of Arbitrators provides in the world, and focusing both on the training element and the assessment element of it, and how we make sure that quality standards are applied throughout the globe consistently. And of course, if you do have any questions after my presentation, we'll be very happy to answer those. The main object of the Chartered Institute of Arbitrators is the global promotion of alternative dispute resolution methods. I will not insist on what that is, because I think the presentation has explained it enough. And with regards to training and education opportunities, which I'm responsible for at the Chartered Institute of Arbitrators, we have a golden thread framework. And the reason for that is that we have a globalized syllabus with a consistent and quality assured training and assessment model for CIArb. What that means in practice is that everyone who trains with the Chartered Institute of Arbitrators, either at headquarters in London or through the 41 branches, and anyone who has completed successfully the training with CIArb and currently holds the post-nominals of the Institute as a member of the Institute, that could be at different levels, as I will explain very soon, has a quality attached to that. So that's the quality of a consistent, quality assured training and assessment model. Those are globally recognized post-nominals, which are an indication of professionalism, ethic, and consistency throughout the globe. We have different trainings that we offer at CIArb through our branches and also through partnerships. Partnership is something we particularly value because we are very aware that sometimes, and this is true for us in London, but it's also true for the branches locally, that in order to reach some specific audiences, there are some training partnerships which might be particularly interesting. And this is why I am glad to be joining this particular webinar today. So we have introduction courses. The purposes of the introduction courses is, as the same name suggests, is to introduce and to raise awareness on particular disciplines. We have a general online introduction to ADR, which, as you can see from this graph, it is an online introduction, and it's an introduction to the different methods of alternative dispute resolution. And then we train for different disciplines, domestic arbitration, and the branches locally also train on domestic arbitration, because the arbitration legislation varies from countries and regions to other countries and regions. We train on international arbitration, co-structured adjudication, and mediation. Any introduction course, upon completion of the relevant course and the assessment, which is the same assessment taken centrally with us as CIArb, would lead to join the CIArb as an associate member. This is why the membership grade is indicated as A CIArb. That means associate member of the Chartered Institute of Arbitrators. Anyone who would like to develop a deeper knowledge and understanding and develop relevant skills in any of these disciplines can then embark on a learning journey on what we call and refer to as the pathway models. Pathway because they are paths that lead to the membership of the Institute. And again, these are delivered in the different disciplines and there are different levels of training. There is what we call the Module 1 training, Module 2 training, Module 3. I will explain further in a second. And they lead to the level of membership of the Institute, or even fellowship of the Institute. We are also aware that there might be people who already are practicing in one of these fields, let's say international arbitration. So they have acquired, let's say, relevant years of experience in the field. So and we recognize that experience as of value. So we do not ask, those practitioners to embark on a learning journey that might take 3 or even 6 months or even more with us, but we have what are called accelerated routes to membership or accelerated routes to fellowship. Those are fast-track workshops followed by assessments in which we make sure that and assess that that experience that the person brings in is actually up to the standards that CIArb recognize as being the needed standards at different levels of membership. So the accelerated route to membership, it is equivalent to a module 1 and would lead whoever takes that accelerated route to be a member of the CIArb. And the accelerated route to fellowship requires 10 years of experience as opposed to the 5 years required in the accelerated route to membership, and would lead to the fellowship of CIArb. We also have diplomas. We have a diploma in international commercial arbitration. This is led by top global practitioners. We have normally run this diploma physically in Oxford for many years until the pandemic arrived, and we have converted the diploma in a virtual diploma. The next edition is starting in September. And we have had, at the last edition in March, 34 participants from over 21 jurisdictions. So the diversity of that is really great. And that is, again, focused course where the pathway is condensed in one learning experience. It does require some previous international arbitration experience, so there is an entry requirement, but it is one of our, I would say, flagship courses at CIArb, and we also have a diploma in maritime arbitration. I hope that this will show. Yes, here we are. So as you can see, this is what I was just describing. The basic training at CIArb is the online introduction to ADR, and what then branches most of the time develop, depending on the market and the regional needs, they develop introduction to the different disciplines. And this is what the CIArb Pakistan branch is running for the first time at the end of August, the introduction to international arbitration. Following that introduction, you can continue, the journey, as I have said, and this is, for domestic arbitration, adjudication, and mediation pathway. There is a module 1, which duration is 3 months. There is a module 2, which covers the law of obligations. And in this case, it's a 6 months module, but whoever has a legal qualifications can demonstrate that relevant knowledge and skills through an exemption test, which is taken centrally with us and would allow learners to skip that module and move directly into module 3 level, which would allow anyone to join the Institute as a fellow. And as you can see here on the right, there are the accelerated routes to membership and accelerated routes to fellowship I was referring to before. How is a module delivered? In the case of an introduction, it's normally delivered over 1 or 2 days, depending on the fatigue that is associated with virtual training. It has been traditional 1 day physical training. It has been converted more in 1.5 day of virtual training. In the case of module 1, this is a 3 months module. So we run it 3 times in the year. So you can see a starting time in September, January, April, and this is at the headquarters. And it is a combination of self-study and tutorials where global CIArb faculty experts, would deliver a very interactive session with the candidates in order for them to engage in more significant learning. And that alternation of self-study and tutorial time is carried out throughout until the examination takes place at the end of the 3 months. This is the structure of a training. We deliver training at what we call 12BS. It's just because the Chartered Institute of Arbitrators, it is based in 12 Bloomsbury Square in London. So that's the headquarters. And then we deliver through the branches, as in the case of Pakistan, and through partners. There is a centralized assessment. And the reason why we run the assessment centrally at HQ, it's because we want to ensure global quality to what, and the fact that those post-nominals have the same meaning and are, and carry the same standards throughout the entire world. So we draft the assessment, we commission experts to draft the assessment, to moderate whatever the assessment is, and also the marking and the moderation of the assessment is carried out by independent experts. We have centralized assessment dates in the sense that compatibly with time zones, the assessments run at the same time across the globe. We have a central booking and payment system, and due to the pandemic, the exams were once open, closed book exams that would take place in a physical space over 3 hours. We now have courseworks. So what a normal exam for module 1 would look like is, for example, a coursework to be delivered over 48 hours in a space of 5 days, and this is an open book exam. But at an introduction level, the assessment is very accessible. It is an online multiple choice question that can be completed after taking the introduction course, which will be the case for the Introduction to International Arbitration taking place in Pakistan at the end of the month. As I said before, the accelerated route to membership is a 2 days workshop with a centralized assessment on the second day. And the ARF is a 3 days, 2 days workshop and a centralized assessment on the third day. This is for those who have previous experience and want a fast track route to membership or fellowship of the Institute. The diploma, it's a new diploma because it's delivered virtually, and that has required adaptation of the syllabus and of the assessments. And in all cases, the materials are the same materials. They are used across the globe. So this is workbooks, slides, exercises, and anything else. It's the same syllabus, which is taught globally. We delivered them in a virtual learning environment, which can be, physical, or can be, we use what we call Learn ADR. It's a Moodle system, and we have a virtual classroom, which is part of the environment. So we can deliver even combined physical and virtual, as it will be the case with the branch courses in Pakistan. As I say, quality is really important to us, being a global institute, and the way we ensure globally is through what we call an approved faculty list. So whoever teaches CIArb courses needs to be approved to do so, and this means that they would have the expertise, they would have the knowledge and skills, also the teaching experience, which is required to deliver these courses to the best possible standards. This is in a nutshell what CIArb training is about, and if you do have any question, please let me know. I hope this helps.
The
Imran,
participants can use the chat box, or they can also use the raise hand option in Zoom for their questions, please.
I'll just read one of the questions that was asked earlier, which was about, I think, Rashid Hussain, you asked this question. Government organizations and departments and institutions discourage arbitration, even disown the ingenious decisions if awarded against them. How to change this culture? I mean, as I mentioned, this is a typical example of parties not understanding their rights and obligations and not implementing what's written in the contract. And this is one of the key causes of disputes. And I think it all goes back to training, development, and creating awareness. One thing that I'll explain, when we are working for clients, we actually do a lot of joint training and joint working with our clients as well. How it helps us, having joint training delivered by somebody that, of course, we pay for something, it just raises that awareness within the client teams as well. Because if we know something different from them and they don't maybe know or just don't want to know, it becomes very difficult when you've had joint training together, when you've had contract management principles developed together, when you are working on a shared document that this is how our contracts will operate. This is how challenges, variations, or disputes will occur. I mean, one of the thing is change happens in a construction contract. It's inevitable. Scope changes, weather issue comes in for extension of time, sometimes material just doesn't get delivered on time. Change happens. It's about how we mutually agree on that variation, how our contracts actually provide us with the ability to enable those variations. And those are the key principles that we need to work with our clients to ensure that we are all on the right page, we're all on the same page. I hope that explains. There are a few other questions. Go on, Imran.
I think it was rightly explained by Nasir. I think training is is the essence for the clients and for the practitioners also. I think continuous training helps to develop understanding and concepts, and it would definitely resolve such bottlenecks.
Yeah, I'll just go to another question now, which is Aftab mentioned it, clause 67. Aftab, FIDIC contract is full of time bars. If you've hit a time bar, you've got no choice. So if you've missed your 70 days opportunity of taking the claim into arbitration, the contract just doesn't allow you to do anything. It's all like your notice provisions. And I'll be honest, I'm not an expert on clause 87 because I'm at the moment dealing with 2017 FIDIC. And I know Pakistan's still on 87, which I'm really hoping, please move up. Please go into at least 1999 or 2017 or 2010. 87 is just so last century, which it is. But that's kind of where I'll go in it. Time bar clauses are essential, and that's what makes FIDIC contract so important.
I have a question related with that. What happens if a situation arises in a construction contract in UK? If somebody misses a timeline and he's not allowed to go into arbitration, if he goes into litigation, what will be the response of the court in that matter?
So, I mean, it depends on the contract. So I'll give an example of if a contractor, say, fails to give notice of a claim within a notice period. So I'll give example of FIDIC 99 sort of contracts. Let's look at the red book or even the EPC silver book. Excuse me. Also, to let you all know, I'm suffering from COVID at the moment. So if the contractor fails to give notice, it's time barred. You know, the liability is discharged. It's simple. You don't have anything to come back on, whether it's FIDIC contract, JCT contract, whether it's NEC 3 or 4, whatever contract it is. Time bar is there as your contractual right. So I'll talk about NEC as compensation events. So if the contractor has raised, you know, first they need to raise an early warning. After the early warning has been accepted, they then need to raise a compensation event. Then the client or the employer has, say, 2 weeks to review that compensation event, say yes or no, or ask for an extension. If the employer hasn't given their certificate on that compensation event, the contractor can generate its own certificate and basically say, here it is, pay me the money. It works both ways. So the contractor can be time barred, the employer can be time barred. And that's why it's so important from contract management perspective that we are aware of all the time bar provisions. I mean, I can spend a week talking about time bar clauses, how important and essential they are.
I see a question about this 1940 Act.
1940 Act.
Oh.
This is something really funny which is happening in Pakistan, as it is clearly it is self-explanatory. It is 1940 Act. We are in 2021. The act has never been upgraded, never modernized, though it was provided to us by the British Empire, and it was being implemented in their domain at that point of time as well. But they have actually upgraded it, I think, 4 or 5 times by now.
Yeah. Yeah.
Even India, they have got a new Arbitration Act, which is, and then they have amended that Arbitration Act. There is an Arbitration Act in line with the UNCITRAL model rules going on, which was submitted with the upper house in Senate in Pakistan in 2015. We are hoping to have the new Arbitration Act with us pretty soon. But we have got a new ADR Act in Punjab. It was enacted in 2019. You can refer certain matters like it is mandatory to go through ADR process before going to the court for certain cases. And the act has been enacted in KPK and it has been enacted in Islamabad as well. So we are hoping to have the new Arbitration Act soon.
So I've just made a text of all the different legislations that we have, because in 2011, we had the Arbitration Agreements and Foreign Arbitral Awards Act 2011. It was passed by the Parliament. That was basically that if there are foreign awards, they will be enacted without challenges in the court. 1940 Act did not accept it. And until 2011, we had cases like the Hub case, there was Hitachi case, and few others, Ripali case, something like that.
Rupali,
They were Rupali case. They were all, we had problem. And then ICSID convention was also implemented in Pakistan. So that's, there is some discussions going on, and something that we are very passionate about, lobbying it within Pakistan to actually help and update the Arbitration Act, which will help. A question has just come in about extension of time. Now, that is majority of the work that I do is about extension of time claims. And it's all about having the cause and effect presented in a way, because one of the causes of disputes I mentioned was contractors making a claim, but not having appropriate cause and effect or substantiation to be able to demonstrate how they have been delayed. For example, it rained. Brilliant. It rained. Fine. But how did it actually affect the delivery of your work? Did you implement some provisions, risk mitigation methods? Was there dewatering pump installed before you started excavation? I mean, rain can happen. I mean, we live in the UK, 250 days it rains. If we were to stop work in rain, and we will never work. So it's about having those challenges and risk mitigation being implemented, and for the contractor to then be able to demonstrate how their schedule, their critical path was actually affected before you do extension of time. Now, one of the things is with extension of time, you may agree with the principle that yes, we agree the extension of time, but then the second stage comes in is quantum. How do you actually demonstrate loss? Because extension of time is all about loss and expense. It's all about finding those remedies of how you will be paid if you had to extend your preliminaries or anything else which comes with it. So say your site had a 100-day project, it rained for 12 days. Yes, it rained for 12 days, but that does not mean that you need an extension of time for 12 days. You have to develop and provide cause and effect, how it affected the, critical path. You may only need an extension of time for 3 days, but it depends on the program. And I know we have a lot of experts in Pakistan with Primavera, P6, ESTA, whatever, project management or planning softwares you use. It's all about the cause and effect on that. Is amicable settlement backed by our legal system? Again, contracts.
Nasir?
Yeah, go on.
Sorry to interrupt. Can we let Miss Margherita leave? She has got another appointment.
Yes.
Question and answers.
Yes,
Thank you so much,
Margherita.
Thank you very much. It has been a pleasure.
Thank you so much.
Thank you, Margherita, for being with us and sharing your useful information with us.
Thank you, Imran, for inviting me.
Thank you.
Bye.
Okay. Amicable settlement is a private agreement.
Nasir, you are talking to a very relevant audience here. All of the, I think, participants are active construction managers. So
Oh, excellent.
They must be having a lot of questions for you. But I think if we cannot finish the questions in this sitting, I will recommend them to write down their questions, and
Yeah, absolutely.
I will share your emails with them, and
Yes,
I
please.
think they can send your questions to you through emails also. But
Yes, absolutely.
whatever you can answer right now, you are welcome to do that.
Yeah, so let's do another 5 minutes. I mean, first question was about amicable settlement backed by our legal system. Yes, amicable settlements are backed by every legal system because contracts are private. You can agree to whatever you want to do as long as it is legal, as long as contracts have 5 key requirements. Offer, acceptance, the legal expediency of yourself, so you're not doing it with a minor. It has to be legal, so you can't do an agreement of settlement trading in apologies to use the word trading in drugs. As long as everything is legal, you're more than welcome to have amicable settlement, and you can just draft your settlement agreements that way. I mean, I do a lot of these in terms of defining final account settlements with contractors and clients to help them out close their final account settlements. Can we develop institutes to provide arbitrators instead of choosing by parties, which as per my experience are biased? Is there any law on it? Mian Saab, I think you're the best person to answer that.
This is what we are working on. Like we are in the process of establishing the Chartered Institute's Pakistan branch. So one of the the Chartered Institute has got 2 functions. One of the function is known as DAS, which is Dispute Appointment Service, which is where and the other one is the training of the professionals. So what Chartered Institute does is train the professionals, and then they use their own standardization procedures in providing the arbitrators. So if like let's say, but for that, in order for a case to be referred to the Chartered Institute, the arbitration clause has to be constructed in a way that the dispute should be referred to the Chartered Institute. So that arbitration clause will be developed at the time of the contract. So if the clause involves the Chartered Institute, that in case of a dispute, the matter will be referred to blah, blah, blah to Chartered Institute of Arbitrators. So that at the time of that dispute, the matter will be referred to the Chartered Institute. So what the Chartered Institute is going to do is they are going to fetch 3 CVs from their own, not with the, they will not be imposed by the parties, but the branch will give those 3 CVs and will present them to the parties. So from those specialized CVs, the parties are going to choose arbitrators, 1 arbitrator of their own, or maybe 1 or 1, and then the 2 arbitrators can choose the 3rd umpire. So this is how the transparency works in international arbitration.
Well, I think, yeah, there is one more question. If Nasir, if you could respond to that about COVID-19 pandemic lockdown.
It depends on the jurisdiction. So for example, in the UK, it depends on what contracts you have, what's written in your contract. So if your contract included a pandemic under the definition of the force majeure, you will do that. Now, one needs to understand is in force majeure, you don't recover your money. You may get time, you may be able to terminate your contract, but you're not recovering any money if there is 6-month delay on your project. So no sane contractor would like to implement force majeure on their contracts. What they would essentially like is to implement change of law or to seek an instruction from the employer to delay the works or do works differently. So this is why every claim I've dealt with recently on COVID, it's always been the issue. Is it force majeure? Is it change in law? Or is it an instruction by the employer to the contractor to say, you need to do social distancing, you need to install more side cabins, you need to install more provisions or more PPE and all that. So again, if an instruction like that has been given by the employer pays for it. Happy days for the contractor. And if you haven't given an instruction and let the contractor deal with it based on the current law, then the contractor has to demonstrate what provisions they have installed in response to the law being implemented by the country. So for example, in the UK, construction just never stopped. The legislation said social distancing, but at the same time, it said construction is the backbone of the industry. It should not stop. So if any contractor is coming to me and saying, oh, change in law, COVID. I'm simply saying, no, sorry, tough. It's not change in law, so you're not getting any money. It's a bit tough, but we have to apply the law and the contract as it is.
Well, I think we are coming to the close of this webinar now. One thing I must add for the information of all the participants, that this one-day course has the added advantage for them to become associate members on one-day course only. I think otherwise, if I'm right, please correct me if I'm wrong, Shiraz sir. The normal duration of this course is 3 days.
Yes. So what we've done is we've kind of condensed it in such a way. And also one of the things that I was able to do with the help of Mia Sheraz, of course, the usual cost of this course is £600 plus VAT. And what we've done is, and the test is separate, £72. We've kind of lumped it all in one go. To basically say that, this is the first course, and what it will do is it will help understand international arbitration, help you practice it, help deliver as a party, and inshallah in future, train us to become professional and competent arbitrators. The biggest problem in any jurisdiction when these things happen is I'm sorry to say, it's all the retired old judges who come in and deliver arbitrations. That's their, retirement plan. And my question always comes in is, if there is a ground contamination claim to be decided, what is a judge going to say on that if they are not a trained geotechnical engineer? So if I'm looking for an adjudicator or an arbitrator in a specific matter, so for example, there was an extension of time issue, I'll try and go to a project manager who understands planning rules, who understands critical parts. So best informed in that aspect to make a decision. Whereas if I take my planning and other matter to a family court or criminal law judge who has now become an arbitrator, I've got no hope. I'm sorry. But that's where we as engineers need to train. So we make ourselves available to represent as parties, to develop our case stronger, to be able to negotiate even before we go into arbitration, because we can then understand what is a statement of case, how to respond on it, what substantiation is needed, how the whole procedure works. And that is why it's important. I mean, I think Imran did mention, I am an engineer by background who later trained as a quantity surveyor, chartered procurement, and I qualified in law as well. And the reason to do that was so I can actually sit with whoever there is and talk in their language. So the lawyers don't ditch me and say, oh, you're a bloody engineer. What are you talking about? I can actually talk to them in their language. And same with QSs and other things. And it's helped me. And I'm hoping you will follow the track as well. Mia Saab, would you like to add anything?
Yes, I would like to add, I would like to shed light on the CPAC contracts turning now becoming more than $100 billion in Pakistan. And it is quite amazing to know that the international arbitration industry is now keeping an eye on these CPAC contracts. Besides going into arbitration, we are going to have dispute adjudication boards. We are going to have dispute review boards. We are going to have dispute avoidance panels. So we don't have the expertise available in Pakistan. Where are we going to get these experts before the case is being hit by the arbitration? So this is we need to develop this pool, and we need to and there is a lot of room available in this area. Like the engineers who are going to be legally qualified in arbitration and in adjudication, they are going to be the shining stars in the near future, I believe.
Yeah, I think we close this webinar with this motivation for all the participants. A little investment at this stage will bring big fruits for them. I think added with their professional experience which they are gaining right now. I think this training is going to help them in a big way in their profession. So I'll thank again Nasir Khan and Mian Sheraz Thank you very much for being with us and sharing this valuable information with us. And I think I'll, if there are any future questions, I will share with you through your emails. Thank you very much.
Thank you very much. Assalamu alaikum,
Thank
everybody.
you very much, everybody. I think we